Exceptions are: first, sale by mercantile agent; second, sale by joint owner; third, sale by person under a voidable contract; fourth, sale by seller in possession after sale; fifth, sale by buyer in possession before transfer of ownership; sixth, effect of stoppel; 7, sale by unpaid seller; 8, sale by persons covered under other acts, who are covered under other acts. So now let's take these one by one and study about them. First, sale by mercantile agent. Now we know that mercantile agent is a person who is appointed by the principal to do some acts on the behalf of the principal. So normally what mercantile agent does is he gets the goods from the principal. Mind you, he does not purchase them from the principal. The principal just gives him the goods to sell it ahead. And what he does is, he takes the goods, keeps them in his custody and sells them. Now, does the mercantile agent become an owner here? No, he doesn't. He only takes the goods from principal. He does not purchase them. So he does not become the owner. Yet, he can effect a proper sale. Yet, he can effect a proper transfer of goods. Okay. So, even though mercantile agent is not an owner himself, he can still transfer the goods. He can still transfer the ownership in the goods, provided some conditions are satisfied. First of which is possession with the consent. Mercantile agent possesses with the consent of principal. He possesses the goods with the agreement, with the authority, with the consent of the principal. Second, he should be acting in the ordinary course of business. He should be acting in the ordinary course of business. Now, what do you mean by ordinary course of? In the normal, way as a person with a normal prudence would act for conducting that business. In a way as to how that business is conducted, required by the business. So he should be acting normally for doing that business. He should not be going out of the way for selling the goods. So whatever he is doing, selling or purchasing or whatever he is doing, he should be doing it on the behalf of the principal and in the normal way as it is to be done. Third, the buyer has acted in good faith. The buyer does not know that the mercantile agent is not the actual owner, yet he acts in good faith, yet he believes that he is the owner and purchases in good faith without any doubt. Fourth, no notice of no authority to sell. The agent should not have no authority to sell. He should rather have the authority to sell. Many times what happens is, principal serves the notice of no authority to sell to the agent. Now, the notice of no authority to sell is, that is, he tells the agent that now you are not supposed to sell. So that means the agent now does not have the authority to sell. And if he sells, even after being served no notice, no authority to sell, then there cannot be a proper sale. Then the agent will be personally liable for such a sale. However, if he does not have any such notice and is acting under the authority of the principal in the ordinary course of business, then there should be no problem in selling. a mercantile agent can transfer a good title to the buyer. The next is sale by joint owner. Now, who's a joint owner? A joint owner is a person who owns a property, who owns some goods along with one or more persons. Now, let's say there are two persons, A and B. Now, they own a gold bar. This is a 1 kg gold bar which is jointly owned by A and B. This is jointly owned by A and B. That means A and B both jointly own this gold bar. This gold bar is jointly owned by A and B. That means A and B are joint owners here. We cannot say that only A is the owner. We cannot say that only B is the owner. But both of them jointly are the owners here. So they become joint owners. In the same way, let's say there are two persons, X and Y, and they jointly own shares in, let's say, Tata Steel. So they jointly own shares in Tata Steel. So again, A and B here become, or rather X and Y here become joint owners of the shares of Tata Steel. So both of them have the rights of ownership. Both of them become owners here. So now if any one of them sells the gold bar or the shares, can he do it? Now the important thing here is to understand is that A and B are not non-owners. It is just that they do not have complete ownership. Their ownership is divided. They do not have complete ownership. We cannot call them non-owners. It is just that their ownership is divided between the two. So can A on his own self sell the gold bar, or can Y on his own self sell the shares of Tata Steel that X and Y jointly own? Can this be done? This can be done, provided these conditions are satisfied. And what are the conditions? First, sole possession with others' consent. Now if there are more owners, let's say there is Z also here. So now there are 3 owners. So when X sells it to P, X sells it to P. P is the buyer. So when X sells these shares to P, he should have the sole possession with others' consent. That means the shares should be in the possession of X with the consent of Y and Z. Second, buyer has acted in good faith. And third, no notice of no authority to sell. Z and Y should not have given X any notice of no authority to sell. That means X should have the authority to sell. Okay. So the next is sale by person under voidable contract. You should know that a voidable contract is a contract which has the ability of becoming void. It has the ability of becoming void. That means it is enforceable at the option of one party but not at the option of the other party. Now, let's say, I own a house and you come to me, you beat me and get the papers of the house signed by me, in your favor. Now, this contract is entered under coercion. Correct? So now, can I sell this house? I've already sold it to you under coercion, that is avoidable contract. I've sold it to you, but can I sell it to someone else now? Yes, I can sell it to someone else. Because this contract is voidable at my option. I can always avoid this contract and sell it further. Okay, but this is not the point that we want to discuss here. The point is from your angle, from the person who has applied coercion. Can you sell it here? See, you own the house under avoidable contract. That means the title of the house is not clear. I can anytime avoid the contract and the house will come back to me. But what if you sell it to somebody else? Because till the time I do not avoid the contract remains valid. That means the ownership is with you. And since the ownership is with you, you transfer it to somebody else. Can you do it? Yes, you can do it. If I have not cancelled the contract, or you have sold the house before I have cancelled the contract, you can always do this contract. This contract would be valid. So, the conditions are: you should possess the goods under voidable contract, that you are doing. You should sell the goods before the contract is avoided, before the contract is cancelled, that also you are doing. And the buyer should have acted in good faith. That means he should not have a doubt that you do not have the right to sell the house, or that you possess the house under avoidable contract. He should purchase in good faith. Now you would see that this is the common point. It comes in all the points that in all the exceptions, that the buyer should have acted in good faith. The next exception is sale by seller in possession after sale. Sale by a seller in possession after sale. That means a seller has already sold the goods to a buyer, but he is still in possession of the goods. Only the possession remains with him. That means he has not made the delivery of the goods. Now, can he sell it to somebody else? Let's take an example. There's this person A. A has sold goods to B. Okay. However, A has not made delivery. So, he still possesses goods. The goods are in A's possession. Though he has sold the goods to B, the goods are still in A's possession. Now what A is doing is, A is selling these goods to C. A does not, ideally he should have given the delivery to B. He does not give the delivery to B. On the contrary, he sells, he makes a further sell to C. Now, the question is, can he do this? he sells the same goods to C. Can he do it? Yes, he can do it, provided A is in continuous possession of the goods. That means he has not delivered the goods to B. Second, the buyer, he is the buyer that we are talking about here. The buyer has no knowledge of previous sale. The buyer does not know that there's a sale between A and B. C should not be knowing that. And he has acted in good faith. Without any doubt, he has purchased the goods. So, this will constitute a proper sale. Now, the important thing to note here is, once A sells the goods to B, A does not remain the owner of the goods. Yet, the law says he can make a transfer to C. He can sell the goods to C. Though he is not the ownership, yet he can transfer ownership to C. Thus, this is an exception to Namo dat Quod non-habet. The next exception is sale by buyer before transfer of ownership. Now, this is almost a similar case from the buyer's perspective. There's this seller A, and there's this person B who is the buyer. Now, A actually has not sold the goods. He has only delivered the goods. Transferred possession of goods to B. He has only transferred the possession of goods to B. But that does not make B a buyer and A seller. So he does not become a seller, he does not become a buyer. You can see that there is only a bailor and bailee relation between A and B. He remains the owner and B comes in the position of bailee. So bailee is never an owner. Okay? Yet what B does is, since he has the goods, he sells them to C, who is the buyer in this case. He sells them to C, who is the buyer in this case. Now, the question is, can B sell the goods? That means, can B become the seller in this case? Because to become a seller, it is important to have the ownership of the goods, but B does not have the ownership. Yes, B can always become the owner of the goods. Actually, E does not in effect become the owner of the goods, but in law, he can transfer the ownership. Now C will become the real owner of the goods if these conditions are satisfied. That is, buyer should be in possession. Buyer should be in the possession with the consent of the seller. That means A has delivered the goods to B. New buyer has no knowledge of other right of lien. Now C does not have any knowledge between the transaction that has happened between A and B. C does not have any knowledge of this transaction. He does not know if B has taken goods on lien or B has taken goods, as a bailee. What is the transaction between A and B? C does not know. And he has acted in good faith. Okay. It is quite possible that B would be the pledgee here. He would have taken goods as security. He would have given some loan to A and taken the goods as security. So he becomes the pledgee. And then he would have sold the goods to C. The sale will be valid only if C has acted in good faith. He does not have the knowledge of the transaction between A and B. The next exception is stoppel. Now, what do you mean by stoppel? Stoppel means a person would be stopped. It comes from the word stop. But how is it relevant here? It is relevant in the sense that statement or conduct led the buyer to believe that the seller had the authority to sell. Now, let's assume a case wherein this is a shop, okay, and this is the counter where the owners sit and show them to the clients. So there is an owner standing here and there is an owner standing here, okay, and I am a regular entrant in the shop. I regularly go to the shop because both the owners are my friends, okay. So what I do is I go into the shop and at that particular period one of my relatives also enters the shop. So now since I am familiar to these owners, I start showing my relative all the clothes here. Whatever he wants, I start showing him. So what happens is that relative assumes that I am the owner of the shop, and this shop is actually mine and I own the goods here. So these actually are the owners. They are the actual owners, but I am the assumed owner. The buyer has assumed me to be the owner because my conduct or statement, the way I talk, one of my statements would have said, "Oh, come to my shop," or "What goods do you want? Tell me, I'll show you." So these statements or my conduct has made him believe that I am the owner. And what is happening is the actual owners also do not object here because they want their goods to be sold. So they also do not object because they know me and I am selling on their behalf. So they also do not object. So in this scenario, when I am making the sale, it would be considered as a valid transfer. It would be considered as a valid transfer. Now, why would it be considered as a valid transfer? Is because of stoppel. The owners did not stop me from selling the goods. The buyer assumed me to be the owner and purchased the goods from me, and the owners did not stop me. So now the property in the goods gets transferred to the buyer. Even though I do not have any ownership in the goods, I just came there to probably greet them, and my relatives happened to come there and I sold them goods. So even though now I am not the owner of the goods, I can transfer the ownership. Okay, so this is sale by stoppel. Even where the assumed owner is selling the goods, he can transfer a proper title to the buyer. Again, the condition remains that the buyer should purchase in good faith. The buyer should not have a doubt that this assumed owner does not have any ownership in the goods. The next exception is unpaid seller. Now, unpaid seller is a seller who has not got consideration for the goods, to whom the price has not been paid. Even if a small part of price has not been paid, he will be considered as an unpaid seller. Now, one of the rights of unpaid seller is to take the goods back. He can take the goods from the buyer back, or possibly he may not deliver the goods as well. Until the seller might say, you pay me the whole amount, and if you do not pay me, I'll not deliver the goods to you. Now let's say the buyer has paid half of the price, but then he becomes insolvent. What does this unpaid seller do? Simple, he makes another sale. He can always sell it to somebody else. The important thing to note here is, this unpaid seller had already made the sale, so the ownership from him shifted to the buyer. So no, he no longer remains the owner. Yet, since he is an unpaid seller, he has the right to resell the goods, again sell those goods, even though he is not the owner, and still he will be able to transfer a proper title. Okay, so even an unpaid seller who is not an owner can transfer a proper title. Thus, this is an exception to the statement Namo dat Quod non habet. Now, there are exceptions in other acts also that you will find. First is the official receiver or liquidator. Now, who is the official receiver or liquidator? He is a person who is appointed by the court. If somebody declares insolvency, if somebody is declared insolvent, so the court appoints an official liquidator or an official receiver, so that that official liquidator can sell the assets of that insolvent person, and then whatever amount he gets, he pays it to his lenders. It is obvious that he'll always be short of money. If he had more assets, if he had more money, then he'll not be insolvent. So the money that the official liquidator will have will be always less than what he has to pay to the lenders. So he pays them on pro rata basis. That is, he'll pay everybody at 60%, he'll pay everybody at 50%, whatever the amount. So now what the official liquidator is doing, he is taking the assets of the insolvent person and selling them to outsiders. Now the important thing to note here is, the official liquidator is not the owner. He is only appointed by the court to sell the assets. Yet, even after not being an owner, he can transfer a proper title, proper ownership to the buyer. Again, finder of goods. We've already studied about finder of goods, that it is the duty of the finder of goods to preserve the goods, to search for the real owner, and then return the goods back to him. But what if the finder of goods does not get the real owner? Or what if there are a lot of expenses that he has to incur in preserving the goods? We know that in that case, the finder of goods can dispose of the goods, can sell the goods. Again, the important thing to note here is, finder of goods is not the actual owner. He does not have the ownership. Yet, when he sells the goods, he transfers a proper title. Next is sale by pawnee under pledge. We've already studied this transaction. Now let's say there's a person A and there's a person B. Now person A has taken a loan of rupees, let's say 10,000 from B, and he has given him gold as security. Gold has been given by him as security. Now, what he may do is, if A does not repay him, sell that gold to C, and he'll be able to transfer a proper title to C. Even though B here is a pawnee, he's a pledgee, he does not have the general property in the goods, he only has a special property, he cannot sell the goods. Yet, if this is a situation where A defaults, so B gets the right to sell the security even though he is not an owner. Okay. So these were the exceptions to the Latin maxim Namo dat Quod non habet.